Welcome to the next episode of AIAF Podcast. I'm Anna Smirnova, and I will be your host today for the episode of AIAF Podcast together with my colleague, Christophe Bertrand. Christophe, how are you doing today?
I'm doing very well. Thank you very much, Anna.
Today we have a super special discussion, and it's not only because of the topic, which is actual and extremely relevant for all the sports lawyers around the world, but also because of the person with whom we are going to have this discussion today. This episode of AIAF Podcast will be dedicated to multi-club ownership and whether and how it should be regulated. But before we begin, two quick reminders to all our listeners. First, as always, please follow us on all social media platforms. And the second, don't forget to register for the AIAF Congress, which will be in the first days of October this year in Edinburgh. Having said that, it's a real pleasure to introduce someone who is not just working in the football law, but genuinely shaping the world of football law around the world. Welcome, Marcos Motta, one of the leading figures of global sports law, for decades founding partner of the Bichara Motta law firm in Brazil. Marcos is involved in most complex and most influential issues of international football. He's advising FIFA, Brazilian Football Confederation, other federations, sport clubs on most striking matters of football business, such as third-party influence, third-party ownership, financial regulations. In Brazil, Marcos is playing a leading role for the regulations of football internally on the national level. He played a role in development of the landmark Pelé law, and nowadays he's contributing a lot to the sporting success and business success of Brazilian clubs. Marcos is nowadays the vice president of Flamengo Football Club. And on a personal note, it's a real pleasure and privilege for myself to have known Marcos for many past years. Marcos, thanks a lot for being with us today. Thank you for joining. How are you doing?
All good, Anna. Thank you so much. It's always good to see you, Christophe, and all AIAF colleagues. It's a pleasure and a privilege to be here with you today to discuss this hot topic that we're facing now about MCOs and club investments.
Before we dive into multi-club ownership, for our younger generation of listeners, we must spend a few moments on talking about yourself and how you landed in football law. You definitely have something to share with us.
Yes, Anna. For those who doesn't know, and I'm very proud to tell how I got into this field. Basically, my entry into sports law was not planned. It was accidental. I finished my law school in 1994. And right after I joined a tax law firm in Rio de Janeiro as a trainee, then a junior lawyer. In parallel, in 1996, Flamengo, the club that I supported my entire life, and now I'm currently proudly one of the vice presidents, began a new administration. This was in 1997. And they have restructured the whole football department. Through personal connections, friend of mine, they opened the door and I walked in. Not as a legal advisor of Flamengo, but as a director of the youth squads of Flamengo. And this was that was a very important momentum because that's how I learned a lot about behind the scenes of football, the reality of football. Not the 1%, the 0.01% that you see the highlights in the news in a global scale, but the real South American grassroots football. So, the LLM in International Economic Law in Warwick University in England in 1999 came later, 3 years later, and this definitely has sharpened my tools. Lucky me, at the end of 99, while I was holding the masters in the UK, Flamengo has signed a contract with ISL. For those who doesn't know, ISL was a dominant Swiss-based sport marketing company that basically revolutionized the entire commercialization of the major international sports events. So since I was living in the UK, Flamengo has appointed me as the international representative of ISL. And ISL had a very close connection with FIFA. And that's how I met some friends that I know nowadays, like Paulo, Omar, even Patricia, when we were in opposite sides in Ronaldinho Gaúcho case in 2000. She was representing Paris Saint-Germain, Canal Plus, and I was representing Grêmio in Brazil. So what I found in that moment is it was a world of international negotiations, players' contracts, federation rules, cross-border disputes, jurisdiction, international jurisdiction that nobody in Brazil was really specialized in that time. There was no textbooks or sports law courses or masters. You learned by doing. So that's my school. So I spent more than 5 years doing that before we found Bichara Motta with one of my partners, Bichara. And we built a firm with the true conviction that Brazil would eventually produce world-class sports lawyers, not just players and agents. And I think that was happened. So just to finish this intro, to the young lawyers that are listening to us, I always say is try to find the gap between the rules and the reality of the sports you love. This gap is exactly where most interesting legal works lives. Okay? So fill in the gaps. Find the gap and fill in the gap. That's the advice that I can give you for, not you, but, the younger lawyers that for sure are listening to us today.
This is a very good introduction also to our topic, because MCO was not just appearing on the blind spot. It appeared exactly in the gap, which was not filled by anyone. So thanks for this introduction of your career. And I think it's a beautiful bridge to go from your career to the topic we are going to explore today. How would you assess MCO in modern football? This is exactly what you have just pointed as a gap in business, as a gap in football. How did it rise on the horizon of international football, where it comes from, and what's the role of MCO nowadays?
It's important to start with saying that multi-club ownership is not a new phenomenon. Some people think that it's new, but it's not. Maybe the scale and sophistication of the current wave is a precedent. This is for sure. So we have variations of multi-club ownership. So from manage the deal to controlling the entire ecosystem. This is the trend. So it's not only controlling a simple transfer, but also take control of the entire ecosystem that a club or an investment is surrounded. The research goes back than most people knowledge. One of the earliest examples of MCO was Parmalat, the Italian food company that owned Parma AC and Palmeiras in Brazil in 1992. Actually, it was between 1992 and 2000. More than once, I traveled to Parma in that time, the beginning of the year 2000, to negotiate contracts with Stefano Tanzi and Arrigo Sacchi for players who were not playing for Palmeiras and not for Parma. So this control of international environment was back to the 2000s. But was ENIC PLC, this is more recent, that which acquired controls Slavia Praga, aka Athens Vicenza, FC Basel in the late 90s, that first triggered a regulatory response from UEFA. I don't know if you remember 97 and 98, because all these clubs, 2 or 3 clubs of this group, of ENIC group, has qualified to UEFA competitions. And UEFA settled a rule prohibiting common control clubs from competing in the same competition. That architecture for 1998 was upheld by CAS in the AEK, I think Slavia Praga against UEFA case. It still remains the bedrock of the current framework. But if you go fast forward to today, if you see the club investment report of UEFA, at the end of 2025, last year, more than 345 clubs worldwide are part of multi-club investment structure, compared to 50 or 6 a few decades ago. Not only this, if you go to the Premier League, at least 3/4 of the Premier League is now linked to MCO, with the English club generally sitting in the top of, let's say, as I call the food chain of the MCO. What makes sense because, economically they are the powerhouse of football nowadays. Set alone, more than 122 top division clubs and 16% of the total have at least one cross-investment relation with another club. So it's here to stay. There is no way back. The issue now is how to address all the do's and don'ts related to MCOs.
So if I understand right, we have a question whether MCO would be considered as a sporting model or like a management structure for the corporate organization behind. My point would be here, but where do we put the players in this construction? That on the one side, football and football club, first of all, is based on the players who are playing the game. But on the other side, when we are talking about MCOs as intersection with business, where and what is the position of a player in this big game of capitals and the corporate structures?
That's a very important topic about players, but a little bit back to the structures, as you mentioned, the advantages are real and should not be dismissed. Okay, so pooling of resources and economies of scale, integrated data and technology system that might provide a more competitive edge, player development and trade and the creation of trade pathways, share philosophy, clubs culture. This is all very beneficial for clubs that are not inserted in well-developed regions. Red Bull vertical play model across Leipzig and Salzburg, New York and Bragantino in Brazil is a clear example. Diversification of financial risks across leagues and markets, brand expansion, sponsorship leverage. This is a great and an interesting model to address. But in the player employment dimension, this is perhaps that concern me mostly nowadays as a practitioner, and it's not the one that receive the most attention in the regulatory debate, which tends to focus on competition integrity harder than labor rights. I think we have to have a mix, a balance among them. In ongoing negotiations, for example, I'm implementing MCO clauses, which is a brand new term for us. Not only smart clauses, but MCO clauses, which our team developed to address all the interests when engaged with clubs in multi-club platforms. But the reality is that players within the MCO occupy a strictly subordinate position in this spectrum. The clubs that sign you, the club that loans you, the club that sell you, they may ultimately answer to the same economic principle. So what's the position of the players here? Your negotiation counterpart is substance your employer across multiple jurisdictions, not only in the club that you are playing for. And Article 18b prohibits contracts that enable a third party to influence employment and transfer decisions. But when the third party is technically the same ownership group operating in separate legal entities, we can circumvent this prohibition while not violating the spirit. So we had clear examples about players and MCO deals. Almada, for example, Thiago Almada is an example. A player won the Brazilian Championship and Copa Libertadores with Botafogo in Brazil. Then was loaned to Lyon in January 2025, so if we remember this. And sold to Atletico de Madrid in July. So this all within one calendar year, across 3 clubs in 3 continents, and this dispute reached FIFA. That imposed a ban in Botafogo, meaning the club that had developed the player into a champion. The player was allegedly an instrument of financial engaging engineering between clubs of related entities in the same group. That's not talent development corridor. This is financial aspect. And on the flip side, we see Savinho. It's a great example. City Football Club has tracked the Brazilian player through their global scouting network and bought the player for Atlético Mineiro for 6.5 million from Brazil. The player did not expect to play for Manchester City, but to go throughout and across all the clubs belonging to the City group. So after playing I think in Holland, he played in 2 or 3 clubs before they reached Girona. And in Girona was the real development happened. And he really highlighted, he played amazing. He was one of the best players in La Liga. And then he was sold internally to City Group for more than 30 million euros. So this is a clear example how City Group value lies in acquisition intelligence and contractual controls to keep Savinho within the network long enough for Girona to unlock him to the Premier League. So the development program was essentially a legal and commercial architecture within a multi-club framework. So you see how the player can be impacted, and I don't see them pretty much protected. So just to finalize this topic, in my opinion, the current framework do not sufficiently address the matter of the players. We need specific provisions requiring maybe that intra-group loans or transfer agreements be fully disclosed to the player, and the player have the stronger rights before consenting to move throughout within the MCO network. So again, for me, the players' issues is something that we lawyers and the governing bodies definitely should address more properly at this stage of the discussions.
Marcos, if I may also ask a question, because I'd love to have your point of view on that. And once again, thank you for being with us on this podcast. And it's a great pleasure again to have you, not being with you, but at least to have you on screen. As many people know, France always like to have laws about things, and so we do in France about MCO. There's an article in the law, in the sports code, that is forbidding MCO, and there's also a sports regulation in the First League forbidding MCO, but it's forbidding MCO on some idea of principles, which are, I think, three. First one, no conflict of interest. It is to prevent the conflict of interest. It is also to prevent controlling other clubs, meaning the independence of two clubs, one to the other. And the third one is no influence on the competition, which actually I think comes back also to what the UEFA sporting regulation on integrity is forbidding. It's also to have no influence on the competition. But as you said, it's here to stay for many reasons. So what is your point of view? At the same time, it's a question of financing the sports, and not only football, not only soccer, because we could consider many sports in that. So there's the need of financing the sports and soccer in particular. It's here to stay. But at the same time, how do you manage to keep those three things: no influence, independence, and no conflict of interest? What are the barriers that where you put the stop? What's your point of view on that?
Yeah, Christophe, you touch a point that I have been asking for over a decade, and the answer maybe has only become more concrete over the years. I think that to answer you properly, you have to get back a little bit to 2015 in a FIFA decisions, for example, to address TPO and TPI, as Anna mentioned at the beginning. So to some degree, I think it was a right decision, because you said a word that for me, it's crucial: prohibition. I mean, the ability of a third party to hold economic rights over players was a profound structure change that could ultimately threaten the integrity of the transfer market and player autonomy. I had the privilege to contribute to the regulatory discussions in Brazil, and as a member of the FIFA TPO working group in 2015, 14 and 15, around that period. And I remain convinced that the principle of ruling the phenomenon was correct. Maybe not banning, but ruling it, yes. So that's why I would like to get back a little bit when you pose this question about influence and so on. Because the banning, as you said, maybe it's proposed in some extent in France, could have consequences. As we see today, capital that previously flowed through TPO arrangements found a new and legally cleaner vehicle in the multi-club ownership. So instead of holding a percentage of a player's rights, economic rights, as a third party, now you acquire clubs that holds the player registration. Remember at the beginning that I said the issue is not to control the player, not to control the transfer deal, but to control the entire ecosystem legally, because this goes beyond, let's say, our sports law and legislation framework. The economic logic behind this is identical of the TPO. Invest in develop human capital, control the exit point, and capture the appreciation. Player registration are, in my opinion, key intangible assets. The goal is to control those assets via internal transfers. Then we go back to the players issue that is out of this discussion, and the focus only the controlling and the integrity of the competition. We have to bear in mind that everything that has been decided so far is in a competition level, meaning in a UEFA level. Of course, FIFA has also addressed this during the Clubs World Cup last year, with the Mexican club that had to drop out of the competition because FIFA decided about this control, this influence. But the definitions about influence and control, in my opinion, are still a little bit opaque. Okay, and the CAS has adopted a very strict, not only UEFA, and I don't know if the French legislators, and you can tell me this more more accurately. I don't know how far and how they will be so strict in the definition, because for me, the key is the definition and the extent about the influence and how to manage this multi-management of different clubs belonging to different jurisdiction. So depending on the business model of the MCO, you can have different perspectives. You might call that maybe a strategical development network such as City Football Group and Red Bull, which are focused on player development and sport performance. Maybe you are dealing with a structure that is financially driven, network only motivated primarily by asset appreciation and, as I said, exit opportunities, or hybrid models that can claim development intent but operate financially as a financial vehicle. So it's a very, very complex environment that we are facing. And for me, it's going to be very difficult for the legislators, including the French legislator, to address all these issues because the market is much way faster than the regulators. So it's a big challenge, very similar to the one that we faced in the TPO and TPI early 2015.
If I may just add one word on that, because I agree with you, it's a very difficult matter. And even, yes, we do have an article in the French code, sports code on that, forbidding, but the definition of the prohibition is very difficult even to understand. I mean, not to understand, but to put in place, let's say, or to respect. It says on the same discipline, so the same sport, but what do you do if you have a feminine and a man, a woman and men team? What do you do? And it says no major influence. But how do you understand the no major influence? It's not that easy. It's not that easy as much that there are even right now 2 propositions of law to amend that, to make it whatever, maybe stronger or to maybe more defined, whatever. So that means that even for us, it's not that easy. And we have many examples, even in France. It's the same discipline, no major influence by the law, but only for French company within the French territory. And we know soccer, sports is international competitions. And that means that even us, we have examples of French teams owned by, let's say, a group. There was Textor in Lyon. There was Ineos in Nice. And there is Blueco, Chelsea with Strasbourg. And we even have an example lately of the coach of Strasbourg, because the coach of Chelsea was, thank you, can you please go away? They took the coach of Strasbourg in the middle of the season, and the fans were not very happy about it. So it's to go into your point of view, actually. It's here. It's difficult because we still have to guarantee the no influence on the competition. But how do you do it? Where do you put the limits? It's very difficult.
Yeah. To your point, I think that the problem also is with the market transparency about information, the asymmetry, transparency in information. I mean, an independent club negotiation, for example, the purchase of a player from an MCO flagship is dealing with a seller who knows every detail of the player valuation across multiple markets and multiple seasons of data, for example. The buyer knows what is in public demand. MCO structure allows for in-house transfers at an inflated values when selling externally and at a deflated value when players moves internally. So both distortions harm the market integrity. The UEFA financial control body circular letter, I think from May 2024, I think so. I have to double check. In any case, they rule about the decisive influence and identifying the specific governance pillar through which controls operate for compliance purpose. This to your point. So shareholders or member rights, financial support, governance structure, and players transfers. This sort of categorization is valuable because it maps precisely the mechanism that can distort the market transparency and the integrity of a competition. But that circular was issued as an interpretative tool for a competition, as I said, access purpose. But the same rationality should also drive to enhance the disclosure for the transfer market purpose. So again, most of the regulations and circular areas or whatever are for the competition access purpose only, include the FIFA decision last year and the FIFA Clubs World Cup. So we have a lot to address. We have a lot of gaps, just to get back to my point at the beginning of our podcast.
If I may continue also on this point, because you use another word, I think very important one is transparency. Transparency in regards of the competitions, which actually people are thinking and trying to think about this within the competition's point of view, but also with the datas, I think, because there's not only the competition. What do you do with the informations that could be shared inside of a same group? For example, the datas of a player. Is he running fast, not fast? Is he injured, not injured? So that means that maybe some datas are going to be shared within this group without maybe the player or the employee in general not even knowing it. So that in terms of transparency, that's my question, in terms of transparency, because you go all around the world, what is your point of view of what could be decided or put in place to assure this transparency?
For me, one the key issues, for example, maybe is to address this in international, let's say, standpoint through the TMS. I think that TMS is only address, let's say, one perspective of a deal, not all. So from a transparency standpoint, for me, the TMS, as I said, just capture the headlines of the transfer fee, but not the economic reality of the intra-group arrangements. So low fees, development contribution, academy fees, image right packages tied to transfer agreement. These are all instruments throughout MCO networks, restructure financial flows between the entities. So transparency, as you said, and as I mentioned, for me is key. The UEFA financial sustainability regulations, they require all related parties, for example, transactions to be reported at a price at fair market value. The principle is okay, it's fair, but the enforcement is absolutely inadequate. England is trying to rule this somehow with the Football Governance Act in 2025. They are trying to move in the right direction by making these transparency principles more clear for the ownership purpose. So this independent regulator, they established that a club ownership, that among their issues, it intends to review a game report back to 2024, I think. So we should watch that process carefully, okay? But this is only in one jurisdiction. I mean, England is trying to do so. Brazil is trying to do so. France is trying to do so. But the regulatory framework available to an MCO operating in England, in France, in Belgium, in Brazil simultaneously is vast. So we have to try to shift this outside of a specific jurisdiction. This is not hypothetical. This is the current practice. As I said, the market's much way faster than the regulator, than us, and it's not going to be easy to address and not properly to address all questions related to MCOs, because at the end of the day, yes, might have some, let's say, sport impact, but most of the time is definitely with an economic nature. So very complex and very complicated for us.
So to sum up actually what we have just discussed between you two, I see at least that MCOs nowadays would be to a certain extent, a sort of a functional replacement to the TPI, GPO systems that used to be actively implemented 10 years ago. Nowadays, it's a much more complex replacement. And coming back to the point that Christophe mentioned about transparency, I see it on a different levels nowadays, because transparency is a club vis-a-vis a player, a club vis-a-vis other clubs, clubs within the structure or outside the structure, a club vis-a-vis the national federation, or the whole group vis-a-vis the international regulators such as UEFA or FIFA. I'm afraid in this multiple layers of governance, we are missing one actor who is essential for football fans and supporters. How do we ensure their interest, that the whole business models that are implemented by clubs and their corporate regulators are addressing also the interests of the fan groups? So Christophe already mentioned the story between Chelsea and Strasbourg. How nowadays, Marcos, how do you find it plausible or not plausible to ensure the rights of the fan groups with these complicated structures?
Likewise, the player's perspective, I think the fans' perspective has also been neglected in some extent. Because when you're talking about investment, ownership, control, influence, this is not only a sentimental or economic issue. This is a question of to be legit and ultimately of the social license under which the football operates. I mean, we football operators, we are acting, as I said, under a social license. Christophe mentioned Strasbourg and Chelsea. This is a great example. And you see Strasbourg captain Emmanuel Emenga score, I don't know how many goals in how many matches. And he was booed by his own fans after his move to Chelsea was announced. So a club's captain, it's the most visible on-field leader, becomes a symbol of subordination of a MCO rather than an identity of the club for the supporters' perspective. So the commercial case of MCO also, most of the times, includes indeed the culture and political influence. This is for sure. And in many nations, the football is deeply embedded in the culture that, and the ownership structure can bring political, social, and commercial influence. And that observation in both ways, club perspective, investors' perspective, supporter perspective. We cannot ignore, as I said, club's culture. For me, club's culture is one of the main pillars that moves our industry, okay? And some demonstrations in Brazil last week, in England, as you said, are not just about bad results. It's about how these new actors in our industry are playing the game, okay? So I say this as a vice president of Flamengo. I understand in a visceral standpoint what a clubs mean to a community. We have over 45 million supporters in Brazil. We are the biggest club in Americas. It's not an asset class. It's a cultural institution, a nation. We have witnesses, cases where a club was denied, for example, the right to compete in a certain European competition or FIFA competition for which they have qualified on the pitch on a sporting merit because ownership decisions. So this highlights the risk for fans who may be punished for decisions taken by owners or by decision bodies who wider business interests extend far beyond the local pitch and the club's culture. So the participation of fans in this process, and maybe later we can discuss what's next in the MCO landscape, but the participation of the fans, the participation of the players, for me, this is imperial and crucial, not for the banning, but to create a beneficial ecosystem that at the end of the day can benefit all, not only one side.
How do we protect the identity of the clubs? With all what you have just mentioned, aren't we risking one day to face the situation that we are having the competition not between the authentic, genuine clubs with historical tradition behind and the social communities supporting these clubs, but we are facing some kind of a competition of groups between groups which are not uniting the originality of the clubs themselves, but the originality of the owners of the structures behind these clubs. How do we keep this in balance so that we keep still the competition between clubs and not between the businessmen?
Yeah, I would like to hear Christophe on this topic, but what I can say is based on our experience, and you have been advising investments, club acquisitions, M&As, all these aspects of clubs investments and MMCOs and multi-club ownership platforms. And I think that we are based in concrete examples and concrete cases that most of the investors or the investment groups, because maybe you can have an investor invest in only one club, maybe you can have an investor invest in a multi-club platform, is that they have already, most of them, at least those that are already in the market and those that are trying to follow the business model that are properly operating in the market, they have realized already that club's culture is imperative for the success of their business. And we are talking here about investments. And when you are playing with investments, sometimes not from your pocket, sometimes you are a private equity, sometimes you are a pool of investors, that a club is an asset like any other asset, maybe in an industry in India or in Asia. And also we have a football club in England or in Brazil. So in order to protect your investment, you have to know your business. You have to know your client. It's like us lawyers. Know your client. This is a golden rule, right? Also for the investors. Know your club. So again, based on our experience, when, for example, an investment group or an MCO comes to Brazil and try to do a club's acquisition, they do a proper assessment of the club's, local club's culture, their identity, their supporters, the culture of the city, of the land, the geographical landscape, which kind, if it's the south of Brazil, it's more European. Is it from the north of Brazil, it's more African. If it's in Rio de Janeiro, this is the samba and the Cristo Redentor, because they know that at the end of the day, playing along with this culture, as I said, is imperial for the success of the investment. So I think this is already in a move, okay? But this is based in really bad examples that we had in the past.
Marcos, are you aware of, throughout the world, what is happening on regulation? I mean, regulating MCOs, because there are many points that you developed, but at the end of the day, maybe the question will be, how do you regulate it? What is the stage right now of regulations? Are there discussions to make some, I don't know, maybe more clearer regulations, or to put some limits? Different sports, maybe, because we're speaking about football or soccer, but it concerns all sports. So what are you aware of in terms of discussions on regulating MCOs throughout the world?
I think that most of the regulations that you see nowadays are in a national level, as you mentioned, France. In Brazil, we have some provisions in which you can see that in some extent the MCO controlling influence is addressed. And I remember that I was part of, as Ana said in the beginning, I was part of the wording of Pele Law back to 1998. Then the Lei Geral do Esporte, which is more recent, and we had extended debates about this 5 years ago, and we managed to implement this. In a side note, we have now in Brazil, for example, new financial fair play regulations that are in place, and I was part of the working group. There are clear examples. If you see, the question is no longer whether the MCO should be regulated, but whether the regulator have the institutional capacity and political power to do it properly. In a jurisprudential standpoint, the CAS is very clear to emphasize the strict enforcement. It has stated that it will rigorously uphold the UEFA MCO rules, regardless of the structural complexities or good faith arguments. There is no flexibility for CAS. For example, late share sales cannot be used to retroact, to validate an MCO structure or to fix any breaches. Past approvals do not guarantee, for example, future acceptance. structures like blind trust, as the UEFA decisions, I think in Girona case, are not assured of approvals to go forward. So also the CAS has confirmed that even a mere potential of decisive influence without actual proof of influence constitutes a breach. This sets a very high bar. But the central point that FIFA somehow they have to address this, or they must address this more properly. But if you see the FIFA regulations, you already have some rules there, not only the competition level, as in the FIFA Clubs World Cup last year, that was a competition regulation, as in the UEFA Champions League regulations, but in the FIFA regulations of starts, the RSTP, you see, for example, the TPO, as you mentioned, we see the TPI is there. This has a direct impact on the international dimension of MCO. You have the limitation of loans. It's already there. So this is also very limit the capacity of clubs operating under a multi-club umbrella to flow the transfer of players, young players loaning to one club to another in different jurisdictions. You have the limitation of transfer of players under 18 years old. U18 players also are not allowed to move physically or to be registered internationally. This is also has a direct impact on the MCO, because at the end of the day, it's a race for the new Neymar, for the new Messi, the new Cristiano. So somehow we already have some articles and regulations in place. But I think what is missing is a more broad and specific regulations address for MCO purpose. Maybe we can have some CAS decision to inspire us. Maybe we can have the Brazilian legislation to inspire us. Maybe we have the French legislation. So maybe a mix, which is not easy because the structures has been more and more and more complex. But if you give a minimum framework, not only to ban, to impede, but to create, as I said before, a proper environment that keep this investment flowing into our industry in one side, and the other side protecting all the actors involved in the game, players, agents, eventually the supporters and the investors. So again, not easy, but I think we are in a process to discuss and to debate which is the proper regulation to be published and to be created, for MCO.
I have probably the closing question to sum up everything what we have just discussed, and I prefer that we still stay in this regulatory field because, Marcos, you mentioned a little bit earlier the point, know your client principle for us as lawyers. So how would you approach it as from the side of the regulator? So each regulator imposing the new rules, provisions for the MCOs should know your client, should know what exactly it's going to impact through the regulations. So different levels of regulators, FIFA would be from one level approaching the regulation of MCOs, national federations from different external commercial courts would approach the structures of business rather than football and the independence of sports. So how would you see the approach from different levels of regulators? What exactly they are going to govern? Ownership limits, operational conduct of the groups and clubs. And we mentioned before transparency. Who exactly should be in charge of governing the transparency issues of MCOs?
In my mind, of course, I don't have all the answers, but I have an idea, in my opinion, which would be, let's say, 5 priorities for any serious regulatory framework. Number 1 for me, it's as you said, a mandatory structure separation. So MCO groups must demonstrate a genuine governance independence between clubs, not just a separate legal entities, but separate management structures, separate negotiating authorities on transfers, separate financial accounts without intercompany guarantees or cross default provisions, as we see sometimes. We had a case, I think, of DAC case that showed us that even in a single individual simultaneous managing director of one club and a CEO of another club was sufficient to constitute a decisive influence. Okay. So number one, as I said, mandatory structural separation. Number two, transfer transparency obligation. All the intra-group transfers and loans agreements must be disclosed in full to the relevant national federations and to the FIFA TMS when you have an international dimension. So we have here some obligation, we should have an obligation in a national level and through the TMS in the international level. So domestic TMS and international TMS with independent fair market value assessments, for example, required for any transactions before you move on, before you get the authorization or the release of the eligibility of the player to play in the organized level. Number three, players protection provisions and MCO structure. Okay. So players must have the right, in my opinion, to an independent voice and an independent legal counsel if they are inserted at the MCO level, and the right to refuse maybe the intra-group loans without penalty or without this constitute any breach of contract. Okay, so the prohibition of the third-party influence of employment decisions vis-a-vis the Article 18Bs must be extended to expressly cover the influence exercise through common ownership structures. Number four, I'm talking about five. Number four, we didn't mention this before, but solidarity mechanism and training compensation. Okay, so intra-group transfers used to calculate transfer compensations and solidarity mechanism must be independently valued. We cannot harm the beauty of the the solidarity mechanism and training compensation behind opaque structures and, let's say, sham market value transactions. The logic is the same as a competition, okay? If there is a decisive influence to establish a transfer value that is not the market value, and this disqualified a club, okay, to receive or to be entitled to training compensation and solidarity mechanism, this should be prohibited and the deal should not be completed, okay? This is the fourth suggestion that I have. And finally, a minimum fan representation in the governance. This is a little bit linked to the first one. So any club within an MCO network that participates in a UEFA competition, for example, or in the Brazil competition, or in France, Ligue 1, La Liga, or whatever competition is, should be required to have at least one supporter representative on the boards and in the committee that supervises the operation of that club under the MCO umbrella, with access and full disclosure to the strategic decisions affecting the club's culture and identity. Okay, so for me, just to wrap up and sum up all this we discussed, these are the 5 topics that for me should be covered when you are dealing with any serious attempt to regulate the MCO market.
This is fantastic. I think this is like super valuable information for all of us and for the listeners, as well as for the regulators who are going to think over how to govern the MCOs in the future. Thanks a lot, Marcos. This was absolutely fantastic contribution. I think we could continue forever talking about all the points that you have just mentioned. So I give the floor to Christophe to wrap up or any questions that you might have.
Yeah, thank you, Anna. No more questions. I just hope that all the sports regulators and even legislators will listen to this podcast and to the 5 topics, 5 key points that you summarized at the end, which are definitely the 5 topics to I mean, they have their roadmap now. So it was absolutely fantastic, Marcos. Once again, thank you for being with us. We were sure that you would be extremely valuable to have you on our podcast, and definitely it is true. Thank you very much once again.
As we began in the introduction, I've just mentioned that Marcos is shaping the football law for the last decades, and you still go on doing so. Even with us today for this less than 1 hour, you managed to form up the future regulations of the MCOs. So thank you so much for this. Thanks a lot for your presence here. It was a really pleasure for us both, with me and Christophe, to hear you and to hear your answers to the questions that we try to make not that easy for you. Thank you.
I appreciate that. just a final words here. I think that, I mean, we are lawyers, right? This is a let's say a legal, mostly legal forum. So our job is to give, in this specific MCO, I think our job is to give those at the bottom, meaning the clubs, the players, the fans, a legal architecture that they need to be protected. And to the top of the hierarchy, the hierarchy of the investments, or the top of the pyramid, a legal framework that cultivates and protects the new and welcome money flowing into the industry. And I think that's why the regulation matters. And that's why conversation like this in forums like AIAF is essential and imperial for the good flow of our industry. Thank you so much, Anna, Christophe, AIAF, for this fantastic opportunity to discuss such a hot and fascinating topic as MCO. Thank you so much.
Thank you for your time. Thanks for your input. And for our listeners, for the very end of our session today, I remind to follow us on the platforms and not to forget to register for the Congress in October. Many more interesting topics will follow there. Thank you so much for your attention, and see you in the next episode.